Hey, welcome to All Things Social Security. You're about to see a question from a live viewer and my response, and it may or may not have an attached additional set of information for you, but you'll see a little invitation to that if that's the case. If what you're looking for is representation and you want us to take a look at your claim, please go to joydisability.com and look in your upper left-hand corner for the link for the free SSD evaluation, and we will take care of that for you. Thank you so much. Bye-bye. Enjoy the video.
And Rat's Nest, I want to know what's going on with you. Everything good? Little Nutty's in the house and says, is it possible to postpone ALJ hearings? It is, if there is a decent reason. If you just say, I got to go to a party that day and I don't. So it's always up to the judge. If you've done it before, it might not fly. I find that they tend to be, if it's a reason, I have a feeling that if it was, say, an attorney reason saying scheduling conflict, the ALJ is going to be like, tough tooties. Go get someone to cover it, I think, because I think that, we have to give our availability 5 months in advance, which I had a whole debacle with the availability central processing unit this last month. And I found out that they do not honor. We have to give it 5 months in advance, the first of the month. However, if the first falls on a federal holiday, any rational person would think, okay, it's the second. Now, you don't have to wait till the last day to file it, and that's all true. And I often don't, but June being a month where kids are getting out of school and all this kind of stuff's going on, I like to wait to the last day just to see if anything new is coming about in terms of the personal side of it, that I would have to say not available. So I did it on the first day we came back, the first business day after the first. It was the second, and they said, at a time, now you have full availability. So what that means for us is, if it's full availability, can schedule, any office in the country can schedule us whenever it wants. Now you could always normally, let's say you were like, I do have full availability, so I'm not even going to say otherwise, and I'll let it default to full availability. If we let it default, which was the repercussion of what I did, because it defaults to full availability, the rule is you can no longer use central processing unit to submit any changes in schedule. Everyone's schedule is going to change. I mean, it's 5 months in advance. Nobody even knows their schedule. Hearings aren't even scheduled out that far yet, not to mention all the other work you have scheduled, meetings and whatever. So I said, but I asked, I go, you're not honoring. I go, the SSA actually has a policy, and here it is, POMS, that it bounces to the next business day. And they're like, this is our response. I'm like, okay, I'm going to share it to the world. Thank you. Which I did to like some of my closer colleagues. Only because, you have to know when a rule that is on the books suddenly isn't going to be arbitrarily not applied by the SSA, even when it's in the SSA rules too. Very strange. So a particular segment of the SSA is not using that policy. So at least we know now, because they didn't publish that. They never put that in their information that, by the way, the rule does not apply to this. Yeah. So what I had to do was send a letter. I did it this morning to every OHO that I have, that I'm in the ALJ process with, even though nothing's scheduled for June, and say, and so you know what I did? I'm like, I'm just taking June off from that. I'm going to schedule everything else, all my other work stuff. And rather than having to figure out their time zones and everything, I'm just like, okay, I'm not available for June. Thank you very much. Made it much easier on me. And there's plenty of other times, May, July, August, that they can schedule me for. But boy, did that really tick me off. Like, they're trying to give you an incentive to get it in before the deadline, so that if it's very inconvenient for you, you'll be more incentivized to do it. I'm the one that gets my stuff in like 8 months early. I'm ridiculous. So it really was frustrating for me when I thought I was following the rule in this one instance, and then I got nailed. So you live and you learn, right, guys? But yeah, little nutty, if you have a good reason, I would say do it as soon as you know you can't go, and you got to call the ALJ and you have to get permission. You have to explain, and then whoever answers the phone, the assistant's going to ask the judge, and et cetera, et cetera. I can't imagine them not doing it if you have a decent reason. And do it as soon as you get the hearing date and it's suddenly bad, because they don't give you guys the opportunity to give availability schedules. So I would like to think they would move it once for you. Fan Cave is in the house. Hi, Fan Cave. Hello, got an update from my senator's office. The ALJ has decision back from writer. Wow, did you really bug them to hurry up the decision after you already had the hearing? Yikes. I hope to hear something in the next couple of weeks. Your videos and others have really helped. That's great. I'm fingers crossed for you. I have to tell you guys, that would not be something I would be doing unless it's been like maybe if it's, well, no, if the ALJ is taking, let's say it's 6 months, I'll call the office and be like, what's going on? Is it still, I just want to make sure nothing fell through the cracks. And they'd say, oh no, they were just waiting for the pool of writers to open up, blah, blah, blah. But I never think it's a good idea to rush somebody who's making a very important decision about you. It just doesn't seem like the wisest thing. And going to your senator's office, no less. You're basically spanking the ALJ now, publicly, with some kind of superior aspect, meaning the senators. And I just think that's something that I don't try to do while my client's case is hanging in the wind. Like, if I want to spank somebody, it's going to be after they're safely out of the way. I don't know. That's just how I feel about it. Rolando says, are lawyers' fee paid considered income? To the lawyer? Yeah, of course. We work for it. We get paid. We pay income tax. Or we report it. Whether or not someone makes enough money to have to pay tax is a whole other thing. You might be asking, are the monies, and someone just asked this, I don't know if it was you, it might have been in a post, like a written post, but you might be asking, Rolando, if when you get your back benefits and it is shortchanged by the attorney fee because it's paid directly instead of you having to cut the check, is it considered income? I'm not a tax professional, so I'm going to just say this with more like a speculation. I'm going to make the presumption that it is until I hear otherwise. And you can tell me when you speak to your tax professional. That'd be great if you wanted to report back to everybody. Because think about it. You get some income in. You hire a plumber and you spend some of that back benefits on a plumber. You're going to still pay. You're still going to report the full amount you came in, that came in. Let's say you got $10,000 in back benefits. You paid a plumber $2,000. The $10,000 is still your income. It's your gross income. Now, if you can write off the plumber's thing because you have a business, so be it. Like you fixed your office pipes. That would obviously be a business expense. That would be in a separate part of your tax return, and it would reduce your gross revenues down to gross revenues less business expenses, such as if you're a Schedule C filler outer on a self-employed 1040. Now, the one question is, and I'm not sure, but I thought I heard that workers' comp, when you get your quote unquote gross wages, but then the workers' comp attorney gets to pull out hers or his. I think I heard, and I don't know if this is true, because again, I don't do tax law and I don't care to, but I think I heard that the workers' comp recipient might be able to declare part of it as the attorney fee to get the workers' comp. Now, if that's true, I don't know, but it's something to look into. And if not, is it true? If it is true for them, would it also be, it is also part of the law for Social Security? I don't know. I mean, I don't know, because many, many people, in my opinion, unwisely, but me, I'm biased, do pro se cases. And sometimes they have no choice, so it's not like their choice to do it. If you don't have, if you both get $10,000 in back benefits, you had the luxury of an attorney costing say $2,000, and that person didn't have the luxury of an attorney. They got the same gross amount in as you. Do they have to ultimately be taxed on $10,000 while you're only taxed on $8,000 plus you got the benefit of an attorney? You follow what I'm saying? Like it might be something that would be not really fair. So the person that wasn't able to get an attorney gets screwed by taxes too. I don't know. Just some thoughts as my head spins around that a little bit.